the proposition that a particular provision of the Constitution or a statute in and of itself creates a private right of action. That's not what the issue is here.
No, that's not the issue here. And sometimes the phrase self-executing is used that way. The only thing I would add is sometimes it's used in a different sense. With self-executing treaties or non-self-executing treaties, the issue is whether that treaty has any force as domestic law whatsoever.
Right. But I don't see what is gained by using this term, which is used in different contexts, rather than directly addressing what's involved here, which is the question of who can enforce Section 3 with respect to a presidential candidate. The consequences of what the Colorado Supreme Court did, some people claim, would be quite severe. Would it not permit, would it not lead to the possibility that other states would say, using their choice of law rules and their rules on collateral estoppel, that there's non-mutual collateral estoppel against former President Trump? And so the decision of the Colorado Supreme Court could effectively decide this question for many other states, perhaps all other states. Could it not lead to that consequence?
I don't think so, because Colorado law does not recognize non-mutual collateral estoppel, and I believe the preclusive effect of the decision would be determined by Colorado law rather than the law of another state. But I think your question, Justice Alito, gives rise to an even greater concern, because if this decision does not have preclusive effect in other lawsuits, it opens the possibility that a different factual record could be developed in some of the litigation that occurs in other states, and different factual findings could be entered by state trial court judges. They might conclude, that, as a matter of fact, that President Trump did not have any intent to engage in incitement, or make some other finding that differs from what this trial court judge found.
Yeah, exactly. So in this decision, the trial court in Colorado thought that it was proper to admit the January 6th report, and it also admitted the testimony of an expert who testified about the meaning of certain words and phrases to people who communicate with and among extremists, right? Another state court could reach an opposite conclusion on both of those questions.
Certainly. Other states could conclude that the January 6th report is inadmissible hearsay. They might also conclude that statements within the January 6th report were hearsay, even if the report itself is not. And they could certainly reach a different conclusion with respect to the expert testimony of Professor Simi. Perhaps in another state, we would have time to produce our own sociology expert who would contradict Professor Simi.
Should these considerations be dismissed as simply consequentialist arguments, or do they support a structural argument that supports the position that you're taking here?
I think they all mutually reinforce each other. We have an argument, we believe, that is sufficient to dispose of this case just based on the meaning of officer of the United States, as well as the argument we're making based on term limits. But all of the consequentialist considerations that Your Honor has suggested are additional reasons to reverse the Colorado Supreme Court, although we don't think it's necessary to get into consequences because the law is clearly on our side.
You keep saying term limits. There are other presidential qualifications in the Constitution: age,
yes,
citizenship. There's a separate amendment, the 22nd Amendment, that doesn't permit anyone to run for a second term. We have a history of states disqualifying, not all, but some, of disqualifying candidates who won't be of age if elected. We have a history of at least one state disqualifying someone who wasn't a U.S. citizen.
Right.
Are your arguments limited to Section 3?
Not quite. The question, Justice Sotomayor, is whether the state is violating term limits by adding to or altering the extant qualifications for the presidency in the Constitution. Now,
so you want us to say, I'm wondering why the term limits qualification is important to you.
Because
are you setting up so that if some president runs for a third term, that a state can't disqualify him from the ballot?
Of course a state can disqualify him from the ballot, because that is a qualification that is categorical. It's not defeasible by Congress. So a state is enforcing the Constitution when it says you can't appear on our ballot if you've already served 2 terms as president. The same
if they're underage when elected, and the same if they're not a U.S. citizen.
The same if they're not, well, the same if they're not a U.S. citizen for sure. The age is a little more nuanced because you can imagine a scenario where the person is 34 years old at the time of the election, but he turns 35 before inauguration.
Well,
The
then
state
that
could
would
not-
come up, that would probably come up to us at some point. The state would make a decision and say he's ineligible, and we would have to decide that question then. But my point is, so what, adding qualifications to what term limit is your argument based on?
You're
I'm
changing.
just confused.
Okay. With respect to maybe I'll start with the age example. If a state like Colorado says you can't appear on our presidential ballot unless you are 35 years old on the day of the election, that would be a violation of term limits because there could be a 34-year-old on the day of the election who turns 35 before inauguration day. What Colorado has done here, what their Supreme Court has done, is similar because under Section 3, President Trump needs to qualify during the time that he would hold office. And the Colorado Supreme Court is saying to President Trump, you have to show that you would qualify under Section 3 now, at the time of the election, or at the time that we, the state Supreme
Now
Court.
I understand.
So what?
Now, just a point of clarification so we're all on the same page. When you say term limits, you mean our decision in the term limits case.
Yes, I'm
not the
sorry.
constitutional provision governing term limits.
Yes, U.S. term limits against Thornton. Maybe I should call it Thornton instead of term limits.
That would
I'm
be
sorry.
easier
Does
for
it
you.
have
I was
So,
confused.
does it have something to do with the fact that the particular circumstance that you're talking about can change? Is that what you mean? I'm trying to understand
Yeah.
the distinction between the provision in the Constitution that relates to disqualification on the basis of insurrection behavior and these other provisions that Justice Sotomayor points out. They all seem to me to be extant constitutional requirements. So, but you're drawing a distinction.
Right. I'm drawing a distinction because some of them are categorical.
What do you mean
Such
by
as-
categorical? Whether or not you are an insurrectionist is or is not categorical?
It is not categorical because
Because?
because Congress can lift the disability by a 2/3 vote. And there's
But why does that change the initial determination of whether or not you fall into the category? I don't understand the fact that you can be excused from having been in the category. Why does that not make it a categorical determination?
because we don't know whether President Trump will be excused before he's sworn in, if he wins the election, on January 20th, 2025. And a court that is saying that President Trump has to show now, today, that he would qualify under Section 3 is accelerating the deadline that the Constitution provides for him to obtain a waiver from Congress.
But that's by virtue of the hold, right? Hold office. This is
Correct. Yes, Section 3 bans him only from holding office. It
All right,
does
can
not.
I ask you, now that I have the floor,
Yes.
can I ask you to address your first argument, which is the officer point? Oh, sorry.
Yeah, why don't we?
Can we,
Oh,
is that okay if we do this and then we go to
sure,
that?
sure.
You know, but
Go ahead.
will there be an opportunity to do officer stuff, or should we?
Absolutely.
I just want to understand, so on this theory, what is the sum total of ways that that Section 3 can be enforced? That somebody out there can say, yes, there's been a former president who engaged or led or participated in an insurrection, and so should be disqualified from office, putting aside the officer argument.
Right.
What is the sum total of ways that that enforcement can happen?
So the answer to that question is going to depend on what Your Honor thinks of Griffin's case. So if this court were to affirm the rationale of Griffin's case, then the only way Section 3 could be enforced is through congressional legislation that creates a remedy. So Congress could reinstate the quo warranto provisions that they initially had in the 1870s.
Is that your position?
Yes, because we believe Griffin's case is correctly decided and should be followed.
And how does that fit with a lot of the answers to the questions that we've been given? You said, well, Congress has to have the ability by a 2/3 vote to lift the disqualification.
Right.
But so too, I would think that provision would be in some tension with what you just said.
There is some,
because if Congress has the ability to lift the vote by a 2/3 majority, then surely it can't be right that one house of Congress can do the exact same thing by a simple majority.
Yeah, there certainly is some tension, Justice Kagan, and some commentators have pointed this out. Professor Bode and Professor Paulson criticized Griffin's
Then I
case
must
very
be
sharply.
right.
Well, we don't think this problem is fatal because to us the 2/3 provision that allows Congress to lift a disability is something akin to a pardon power, where Congress, through enforcement legislation, creates a mechanism by which the insurrectionist issue is to be determined by some entity. It could be the legislature. In the case of an elected member of Congress, each house has the ability to judge the qualifications of their members. Or if it's outside the situation of Congress, it would be whatever Congress enacts. So when it was the writs of quo warranto, each federal prosecutor had the authority to bring a quo warranto writ against an incumbent official and seek his ouster from office under Section 3, but it was still subject to that amnesty provision in Section 3 of the 14th Amendment. So we do acknowledge the tension, but we don't think that's an insurmountable obstacle.
I don't even see why there's a tension. If you analogize the lifting by Congress of the disqualification by a 2/3 vote to a pardon, then surely would not argue that the fact that the president or governor can pardon someone from a criminal conviction or a criminal offense means that the person couldn't be prosecuted in the first place for the criminal offense.
That's right.
Right?
Yes.
So I don't see what the tension is. They're two separate things. Did the person engage in this activity, which is prohibited? And second, even if the person did engage in the activity, are there reasons why the disqualification or should be lifted or the pardon should be granted?
That's right. I mean, if the court accepts the holding of Griffin's case, that's exactly the regime that we would have.
Yeah, I don't see there's
Right.
tension, but also there's a limit on what one can infer from the mere fact that Congress can lift the disqualification. You can't infer from that it is impermissible to have a prior determination that the person did engage in the insurrection. You can't make that inference.
Okay.
It's not
Well, but
logical.
Yet, isn't that what you're doing?
What's intention is that you would have the exact same actor and say, look, that actor can lift
Right.
the disqualification by a 2/3 vote, but you're saying only that actor can put the disqualification into effect in the first place, and it can do that by far less than 2/3. It can do that just by a simple majority of one house.
Or it could do that by doing nothing at all, if the holding of Griffin's case is correct, because just congressional inaction would
But that
effectively
means that
act
there
as
will be, the only thing it
Yeah.
takes to have no action
Right.
is, half plus one saying we don't feel like it.
But that's why we tried to characterize our Griffin's case argument the way we did, where we rely on preemption doctrines as well. So we have.
Don't
Why
you
don't
think
we-
Griffin's case is also relevant to trying to figure out what the original public meaning of Section 3 of the 14th Amendment is? It's by the Chief Justice of the United States a year after the 14th Amendment. That seems to me highly probative of what the meaning or understanding of that language, otherwise elusive language, is.
I do think it's probative, Justice Kavanaugh. We didn't rely too heavily on the point that you're making, partly because we have this other opinion from Justice Chase in the Jefferson Davis case. So that argument could potentially boomerang on us, which is why we didn't push it very hard in our briefing. But I think
Thank
Your
you.
Honor is right. This is
Why don't you finish your sentence? And then we'll
it
move
is
on.
relevant and probative for sure. But I think there is other evidence too that might perhaps undercut the usefulness of trying to characterize Griffin's case as completely emblematic of the original understanding.
Now, why don't we move on to the officer point?
Certainly.
And Justice Jackson, I think you.
Yeah, so I had a question about it because you're making a textualist argument. And as I look at Section 3, I see two parts of the first sentence of Section 3. The first is a list of offices that a disqualified person is barred from holding. And the second are specific circumstances that give rise to disqualification. So first, am I right about seeing that there are two different things happening in the first sentence of
Yes,
section? Okay.
for sure.
So are you arguing both in this case or just one? Are you arguing both that the office of the presidency should not be considered one of the barred offices and that a person who previously took the presidential oath is not subject to disqualification?
We are arguing both, Your Honor.
I don't see that in your brief.
Well,
I see a lot of focus on the second, but not on the first.
There is definitely more focus on the second, and we acknowledge that we have a somewhat heavier lift on the first point.
Why? It seems to me that you have a list and president is not on it.
That's certainly an argument in our favor, but there also, with respect to officer of the United States, that's used repeatedly in the Constitution, in the Commissions Clause, in the Appointments Clause, and also in the Impeachment Clause. And every time it appears, it's used in a way that clearly excludes the
No, I
president.
understand, but that's
So
the
we don't-
second argument. So the
That is.
first
And the-
argument is we have a list of offices
Yes.
that a person is barred from holding, right?
Yes.
Under your theory or under the language of, and we see it begins with senator, representative, elector of the president and vice president, and all other civil or military officers.
Offices under the United States.
Offices under the United States.
How
But
it's
the
phrased.
word president or vice president does not appear specifically
That's
in
right.
that list. So I guess I'm trying to understand, are you giving up that argument, and
No.
if so, why?
No, we're not giving it up at all. You're right. The president and the vice president are not specifically listed. But the Anderson litigants claim that they are encompassed within the meaning of the phrase office under the United States.
And do you agree that the framers would have put such a high and significant and important office, sort of smuggled it in through that catch-all phrase?
We don't agree at all. That's why we're still making the argument that the presidency is excluded from the covered offices that are listed at the beginning of Section 3.
I'm sorry, your brief says you didn't take a position on that point.
I'm sorry.
And your brief said, I don't have the site, I apologize. You don't affirmatively argue that point, I think is what your brief said.
In the blue brief?
Yes.
Well, we certainly argued it in the reply brief, and I'll have to look at how we phrased it. But we did point out in our opening brief that there are potential issues if this court were to rule on office under, because that phrase appears in other parts of the Constitution, including the emoluments clause, the impeachment disqualification clause.
Would we
and the
necessarily
liability
have
clause.
to say, I mean, I thought the point was that Section 3 was unique, that there was something happening with Section 3 that could explain why certain offices were left off or whatnot.
Perhaps, but there are also implications from other parts of the Constitution which really help us on the officer of the United States argument in that second part of Section 3, but somewhat cut against us when it comes to office under the United States. And the Anderson litigants point this out in footnote 9 in the red brief, where they say if this court were to say the presidency is an excluded office under the United States, that could imply, for example, the president is not covered by the emoluments.
Mr. Mitchell,
Yes.
stepping back on this, a lot hinges on the difference between, in your argument, between the term office and officer.
Yes.
And I guess I'm wondering, what theory do you have from an original understanding or a textualist perspective why those two terms so closely related would carry such different weight?
Because it's clear from the constitutional text that there are officers that do not hold offices under the United States. For example, the Speaker of the House and the President pro tempore, they're described as officers in Article 1 who are chosen by the legislature. They also have to be officers if they're able to be covered by the Presidential Succession Act, because under the Constitution, only officers can serve when there's a vacancy in both the presidency and the vice presidency. So they're officers, but they're not offices under the United States because of the incompatibility clause, which says that if you're a member of Congress, you cannot simultaneously hold an office under the United States. So that provision of the Constitution clearly demonstrates that members of Congress can't hold offices.
I appreciate that
Yes.
response. Is there anything in the original drafting, history, discussion that you think illuminates why that distinction would carry such profound weight?
Not of which we're aware. So these are textual inferences that we're drawing from constitutional structure, intratextualist analysis.
Yeah.
But we aren't relying necessarily on the thought processes of the people who drafted these provisions because they're unknowable, but even if they were knowable, we're not sure they would be relevant in any event, because this language, especially in Section 3, was enacted as a compromise. There were certainly radical Republicans who wanted to go much further. If you look at some of the earlier drafts that were proposed, some people wanted to ban all insurrectionists from holding office, regardless of whether they previously swore an oath. Some people wanted to go further and ban them even from voting.
Thank you. Thank you, counsel. I just have one very technical question. The statute in 1870, if it were still in effect, would require you to modify your arguments slightly. It was repealed, as you say, in 1948. I tried to find it, but I couldn't. Do you know why it was repealed?
No, we don't know why. It looks like it was done as part of a reorganization of the U.S. Code. So it doesn't appear there was any policy motivation behind that decision. I think a lot of things got repealed during this 1948 decisions that were made.
Okay. Justice Thomas, anything further? Justice Alito?
Is there any history of states using Section 3 as a way to bar federal office holders?
Not that I'm aware, Justice Alito, because of Griffin's case. I mean, Griffin's case has been the law. I shouldn't say that it's been the law because it was just a circuit court decision, but that has been the settled understanding of Section 3 since 1870 when it was decided.
Thank you.
Justice Sotomayor?
Pin down your principal argument on Section 3. you argue that even though the president may or may not qualify, presidency may or may not qualify as an office under the United States, your principal argument is that the president is not an officer of the United States, correct?
Yeah, I would say it a little more forcefully than what Your Honor just described. We believe the presidency is excluded from office under the United States, but the argument we have that he's excluded the president as an officer of the United States is the stronger of the two textually and has fewer implications for other constitutions.
Bit of a gerrymandered rule, isn't it, designed to benefit only your client?
I certainly wouldn't call it gerrymander. That implies nefarious intent.
Well, you didn't make it up. I know some scholars have been discussing it, but just so we're clear, under that reading, only the petitioner is disqualified because virtually every other president except Washington has taken an oath to support the Constitution, correct?
That's right. Every president, to our knowledge, every other president. John Adams might also be excluded because he took the oath as a vice president, which is not an officer. But yes, President Biden would certainly be covered. He took the oath as a member of Congress, and that's true of every previous president.
Would that be true if we were to hold more narrowly in a reversal that it's not Section 3 that's at issue, but Thornton and others as to whether Section 3 can be enforced by states against the president?
That would extend to every presidential candidate, not
Exactly,
just our client.
not just
That's
to
correct.
yours.
Yes.
Okay, thank you.
Justice Kagan?
And if I could just understand, I mean, given that you say you don't have a lot of evidence that the founding or the generation that we're looking at is really thinking about office versus officer of the United States, I mean, it would suggest that we should ask, is that a rule a sensible one? You know, if they had thought about it, what reason would they have given for that rule? And it does seem as though there's no particular reason, and you can think of lots of reasons for the contrary,
Right.
to say that the only people who have engaged in insurrection who are not disqualified from office are presidents who have not held high office before. Why would that rule exist?
I don't think there is a good rationale, given that this was compromise legislation. And sometimes this happens with statutory compromises and even constitutional compromises. There's an agreed upon set of words that can pass both houses of Congress. But different legislators may have had goals and motivations. They didn't all get their way. In a compromise, everyone goes away miserable. But this was the text that was settled upon. And it does seem odd that President Trump would fall through the cracks in a sense. But if officer of the United States means appointed officials, there's just no way he can be covered under Section 3. The court would have to reject our officer argument to get to that point.
And is there any better reason, if you go to the office argument that Justice Jackson was suggesting, is there any better reason for saying that an insurrectionist cannot hold the whole panoply of offices in the United States, but we're perfectly fine with that insurrectionist being president?
I think that's an even tougher argument for us to make as a policy matter, because one would think of all offices, the presidency would be the one you'd want to keep out the Confederate insurrectionists. That's the commander-in-chief of the Army. So, again, that's why we're leaning more on the officer of argument than the office under. We're not conceding office under, but we definitely have the stronger textual case and structural case on officer of the United States.
Thank you.
Thanks.
Justice Gorsuch?
Respond to some of the specific textual arguments on the officer of with respect to the Appointments Clause, the Impeachment Clause, and some of the others.
Yeah, so the way, I'll start with the commission's
The ball has
clause.
been bouncing
Yeah.
on that back and forth, and I wanted to see where you landed today.
There are three different textual inferences that could be drawn from each of those provisions Your Honor just mentioned. But the commission's clause, I think, is the strongest because it says the president shall, commission all the officers of the United States. Shall is mandatory. All is all-encompassing. And the president doesn't commission himself, and he can't commission himself. So that's one of the first problems. I think the Anderson litigants are trying to say, there's somehow an implied exception there because the president obviously can't commission himself, so we should construe that to mean all officers of the United States besides the president. But you also have members of Congress who are not commissioned by the president, and that's because they're not officers of the United States. So the only sensible distinction that we can see, given the language of the commission's clause, is that officers of the United States are appointed officials, and elected officials, such as members of Congress, and the president and the vice president are not. And the impeachment clause reinforces that. The president, the vice president, and all civil officers of the United States shall be removed from office upon impeachment for and conviction of all high crimes and misdemeanors. The president and the vice president are listed separately from officers of the United States. And then, of course, the appointments clause, we know the president is not appointed pursuant to Article 2, neither is the vice president, neither are members of Congress, so they can't be officers either.
And how does Article 1, Section 6 fit into this discussion?
And this is about officers being in the line of succession?
Yes, exactly.
Right, so you have to be an officer to be in the line of succession. We have a federal statute that puts the Speaker and the President pro tempore in the line of succession. They are officers, but they're not officers of the United States because they're not subject to impeachment, they're not commissioned by the President, and they're not appointed pursuant to Article 2. So there is this gap between the term officer and the phrase officers of the United States, reinforcing the idea that officers of the United States is a term of art that doesn't refer just to federal office holders, which is what the Anderson litigants are claiming, but refers only to those who are appointed, not to those who are elected.
Thank you.
Justice Kavanaugh?
And just make sure I understand how you're using Griffin's case again. Section 3 refers to insurrection and raises questions about who decides what processes are to be used. That's ratified in 1868. The next year, Chief Justice Chase opines that states do not have the authority, that only Congress has the authority to enforce that. That could be evidence, as you say, of the original public meaning, at least some evidence. It's a precedent, although not binding. But your point then is it's reinforced because Congress itself relies on that precedent in the Enforcement Act of 1870 and forms the backdrop against which Congress does legislate. And then, as Justice Alito says, the historical practice for 155 years has been that that's the way it's gone. There haven't been state attempts to enforce disqualification under Section 3 against federal officers in the years since. So whether that's a Federalist 37 liquidation argument, it all reinforces what happened back in 1868, 1869, and 1870.
Right.
You want to add to that, alter that?
No, I think that's exactly right. And the last part you mentioned, Your Honor, is crucial to our argument, that Congress relied on Griffin's case. It provided the backdrop against which they legislated, which is why we should read these extant enforcement mechanisms, and right now the only one left is the federal insurrection statute, 2383, as exclusive of state court remedies. It's a form of implied preemption, almost C-clamor's implicit preemption of other remedies, because Congress made these decisions in explicit reliance on Griffin's case.
And if we agree with you on Griffin's case and what you've elaborated on there, that's the end of the case, right?
It should be, yes, unless Congress decides to enact a statute, which we can't rely on.
A new statute in addition to 2383. And just to be clear, under 2383, you agree that someone could be prosecuted for insurrection by federal prosecutors, and if convicted, could be or shall be disqualified then from office.
Yes, but the only caveat that I would add is that our client is arguing that he has presidential immunity, so we would not concede that he can be prosecuted for what he did on January 6th under 2383.
Understood. Asking a question about the theory of 2383. Thank you.
Thank you.
Justice Barrett?
So Griffin's case was a collateral proceeding, so it's habeas relief.
Yes.
Could Griffin have, so even if Section 3 is not a basis for collateral relief in habeas, which was new at the time, could Griffin have raised at his trial or in direct appeal the argument that Judge Sheffy, you can't legitimately sit or constitutionally sit on my case because you're an insurrectionist and you're disqualified? Could he have won then?
No.
Why?
Not if Griffin's case is correct. So a court would have to reject the rationale of Griffin's case to accept what Your Honor is suggesting.
Well, why? Like I said, Griffin's case, I think there's some language that might be a little bit broad, but at bottom, Griffin's case is about a collateral habeas proceeding. And Griffin had brought his case after the fact. He needed a cause of action. Why wouldn't it work in a trial for him to challenge Sheffy's constitutional ability to adjudicate his case?
What Griffin's case holds is that only Congress can provide the means of enforcing Section 3. And under Your Honor's hypothetical, Congress has not enacted any such statute that would give Mr. Griffin the right to raise those types of arguments at his trial. So he would have to await legislation from Congress.
Okay, let's assume that I disagree with you about the officer argument. So Section 3 covers President Trump. Let's say that Congress enacts a quo warranto provision that would allow a state, or I guess it doesn't really matter for this purpose, even a federal prosecutor, to bring such an action against him, to remove him from office in the quo warranto way. Wouldn't that be in some tension with impeachment? He would be extracted from office outside of the process of impeachment. Couldn't then President Trump simply say, well, the only way to get me out of office is the impeachment process and not this quo warranto action?
So I don't know how that would play out, because the quo warranto actions that were brought, that I'm aware of, under the 1870 Enforcement Act, were brought against state officials. And Your Honor's impeachment hypothetical would apply not only to the president, but any federal officer of the United States.
I know.
So I don't know how that played out in the courts and whether anyone ever tried to argue that impeachment was the exclusive remedy for.
Well, I don't think anybody did argue it. I guess what I'm asking is, you said it's Congress's exclusive province. And you also said that it has to apply, after one is holding office, is elected. And I'm asking whether then the implication of your argument is that Congress could not enact such a provision that applied against federal office holders that were covered by Section 3 as opposed to state ones.
I believe they could. And the impeachment clause says that the president, the vice president, and all civil officers of the United States shall be removed from office upon impeachment and conviction. But it doesn't say that's the only way you can remove them. I mean, Congress can defund a position, and effectively, it's not quite the same as formal removal. But the other relevant precedent is Stewart against Laird, when the Jeffersonians repealed the Midnight Judges Act and abolished all of these positions for federal judges. And some people thought that was unconstitutional because they thought the only way you could eliminate federal judges was through impeachment. But Chief Justice Marshall upheld that statute. So that, to me, is a relevant precedent showing that impeachment is not the only way to get rid of a federal official.
Okay, let me just ask one question, and this is just a point of clarification. Does President Trump have any kind of due process right here? I mean, I'm wondering, this kind of goes not to the cause of action point or the preemption point, but more to the question of what procedures he might have been entitled to. You don't make the argument that he was entitled to any, nor did I see the argument that he had any kind of constitutionally protected right to ballot access, so that he was, and constitutionally entitled to an opportunity to be heard. Is that right? He had no due process right?
We made that argument below. We did not make that in our briefs to this court for several reasons. I mean, Your Honor's, I think, suggesting, and this is correct, that the proceedings below, to put it charitably, were highly irregular.
Well, I wasn't suggesting that. I was just
I'm sorry.
asking.
The question seems to suggest that there might be due process issues, but we didn't develop that argument in this court for several reasons. Winning on due process doesn't really do as much for our client as the other arguments that we've made, because that would be a ruling specific to this particular proceeding in the state of Colorado and would leave the door open for Colorado to continue on remand to exclude him from the ballot.
Okay, thank you.
Justice Jackson?
Back to whether the presidency is one of the barred offices, I guess I'm a little surprised at your response to Justice Kagan, because I thought that the history of the 14th Amendment actually provides the reason for why the presidency may not be included. And by that I mean, I didn't see any evidence that the presidency was top of mind for the framers when they were drafting Section 3, because they were actually dealing with a different issue. The pressing concern, at least as I see the historical record, was actually what was going on at lower levels of the government. The possible infiltration and embedding of insurrectionists into the state government apparatus, and the real risk that former Confederates might return to power in the South via state-level elections, either in local offices or as representatives of the states in Congress. And that's a very different lens. If your concern is trying to make sure that these people don't come back through the state apparatus and control the government in that direction, seems to me very different than the worry that an insurrectionist will seize control of the entire national government through the presidency. And so I just am surprised that you would, given the text of the provision and the historical context that seems to demonstrate that their concern or their focus was not about the presidency, I just don't understand why you're giving that argument up.
There is some evidence to suggest that. Justice.
Is there any
But
evidence to suggest that the presidency was what they were focused on?
there is some evidence of that. There were people saying we don't want Jefferson Davis to be elected president, and there was also one of the drafts of Section 3 specifically mentioned the presidency and the vice presidency.
But it wasn't
as an
the
office.
but it wasn't the final.
It wasn't the
enactment,
final.
so
It
where do
wasn't.
we-
Yes,
Right.
I'm sorry. It wasn't the final enactment, but it does show that there was some concern by some people about Confederate insurrectionists ascending to the presidency. And we didn't want to make a law office history type argument where we just look at the historical evidence and pick the evidence that we like and interpret it tendentiously, because the other side can get back with us and throw this countervailing evidence back in our face. So we wanted to focus more on the text of the Constitution, because this was ultimately a compromise provision that was enacted in Section 3.
All right, let me ask you another question about the states, because you have forcefully made an argument about the states not being able to enforce Section 3. So if we agree with you on that, what happens next? I mean, I thought you also wanted us to end the litigation. So is there a possibility that this case continues in federal court if that's our conclusion?
I don't see how it could unless Congress were to enact a statute in response to this court's decision.
So your point is that we would have to say congressional enacting legislation is necessary for either state or federal enforcement.
That's correct.
All right, final question. The Colorado Supreme Court concluded that the violent attempts of the petitioner's supporters in this case to halt the count on January 6th qualified as an insurrection, as defined by Section 3. And I read your opening brief to accept that those events counted as an insurrection, but then your reply seemed to suggest that they were not. So what is your position as to that?
We never accepted or conceded in our opening brief that this was an insurrection. What we said in our opening brief was President Trump did not engage in any act that can plausibly be characterized as insurrection.
All right, so
Because
why
he
would
did
this not be what is your argument that it's not? Your reply brief says that it wasn't because I think you say it did not involve an organized attempt to overthrow the government. So
That's one of many reasons, but for an insurrection, there needs to be an organized, concerted effort to overthrow the government of the United States through violence. And this
so
riot
the point is that a
occurred-
chaotic effort to overthrow the government is not an insurrection?
No, we didn't concede that it's an effort to overthrow the government either, Justice Jackson, right? None of these criteria were met. This was a riot. It was not an insurrection. The events were shameful, criminal, violent, all of those things, but it did not qualify as insurrection as that term is used in Section 3.
Thank you.
Thanks.
Thank you, counsel.
Thank you.
Mr. Murray?
Mr. Chief Justice, and may it please the court. We are here because for the first time since the War of 1812, our nation's capital came under violent assault. For the first time in history, the attack was incited by a sitting president of the United States to disrupt the peaceful transfer of presidential power. By engaging in insurrection against the Constitution, President Trump disqualified himself from public office. As we heard earlier, President Trump's main argument is that this court should create a special exemption to Section 3 that would apply to him and to him alone. He says Section 3 disqualifies all oath-breaking insurrectionists except a former president who never before held other state or federal office. There is no possible rationale for such an exemption, and the court should reject the claim that the framers made an extraordinary mistake. Section 3 uses deliberately broad language to cover all positions of federal power requiring an oath to the Constitution. My friend relies on a claimed difference between an office under and an officer of the United States, but this case does not come down to mere prepositions. The two phrases are two sides of the same coin, referring to any federal office or to anyone who holds one. President Trump's other arguments for reversal ignore the constitutional role of the states in running presidential elections. Under Article 2 and the 10th Amendment, states have the power to ensure that their citizens' electoral votes are not wasted on a candidate who is constitutionally barred from holding office. States are allowed to safeguard their ballots by excluding those who are underage, foreign-born, running for a third presidential term, or, as here, those who have engaged in insurrection against the Constitution in violation of their oath. I welcome the court's questions.
Do you have contemporaneous examples, and by contemporaneous I mean shortly after the adoption of the 14th Amendment, where the states disqualified national candidates, not its own candidates, but national candidates?
The only example I can think of, Justice Thomas, is the example of Congressman Christie, who was elected in Georgia in, I believe, 1868, and the governor of Georgia refused or declined to certify the results of that election because Mr. Christie was disqualified. But I think it's not surprising that there are few examples because we didn't have ballots in the same way back then. Candidates were either write-in or they were party ballots, so the states didn't run the ballots in the same way, and there wouldn't have been a process for determining before an election whether a candidate was qualified, unlike the processes that we have now that states have created under their Article I and Article II powers to run elections.
But it would seem that particularly after Reconstruction and after the Compromise of 1877 and during the period of Redeemers, that you would have that kind of conflict. There were a plethora of Confederates still around. There were any number of people who would continue to either run for state offices or national offices. So it would seem that would suggest that there would at least be a few examples of national candidates being disqualified, if your reading is correct.
Well, there were certainly national candidates who were disqualified by Congress refusing to seat them.
I understand that, but that's not this case. Did states disqualify them? That's what we're talking about here. I understand Congress would not seat them.
Other than the example I gave, no. But again, Your Honor, that's not surprising because there wouldn't have been, states certainly wouldn't have the authority to remove a sitting
So what's the
federal
purpose
officer.
what was the purpose of the Section 3? The states were sending people. The concern was that the former Confederate states would continue being bad actors. And the effort was to prevent them from doing this. You're saying that, well, this also authorized states to disqualify candidates. So what I'm asking you for, if you are right, what are the examples?
Well, Your Honor, the examples are states excluded many candidates for state office, individuals holding state offices. We have a number of published cases of states considering that.
I understand that. I understand the states controlling state elections and state positions. What we are talking about here are national candidates. I understand. You look at Foner or Foote, Shelby Foote, or McPherson, they all talk about, of course, the conflict after the Civil War. And there were people who felt very strongly about retaliating against the South, the radical Republicans. But they did not think about authorizing the South to disqualify national candidates. And that's the argument you're making. And what I would like to know is do you have any examples of this?
Many of those historians have filed briefs in our support in this case, making the point that the idea of the 14th Amendment was that both states and the federal government would ensure rights, and that if states failed to do so, the federal government certainly would also step in. But I think the reason why there aren't examples of states doing this is an idiosyncratic one of the fact that elections worked differently back then. States have a background power under Article 2 and the 10th Amendment to run presidential elections. They didn't use that power to police ballot access until about the 1890s. And by the 1890s, everyone had received amnesty and these issues had become moot. So I don't think the history tells us.
Sort of look at Justice Thomas's question sort of from the 30,000-foot level. I mean, the whole point of the 14th Amendment was to restrict state power, right? States shall not abridge privileges of immunity. They won't deprive people of property without due process. They won't deny equal protection. And on the other hand, it augmented federal power under Section 5. Congress has the power to enforce it. So wouldn't that be the last place that you'd look for authorization for the states, including Confederate states, to enforce, implicitly authorized, to enforce the presidential election process? That seems to be a position that is at at war with the whole thrust of the 14th Amendment and very ahistorical.
No, Your Honor. First, we would locate the state's authority to run presidential elections not in the 14th Amendment, but in Article 2. And that power is nearly plenary to determine.
Yeah, but you're relying on, you have no reliance on Section 3, is that what you're saying?
No, Your Honor. Certainly we have reliance on Section 3 insofar as Article 2 gives states this broad power to determine how their electors are selected, and that broad power implies the narrower power to enforce federal constitutional qualifications.
Well, but the
like
narrower
Section 3.
power you're looking for is the power of disqualification, right? That is a very specific power in the 14th Amendment. And you're saying that was implicitly extended to the states under a clause that doesn't address that at all.
We would say that nothing in the 14th Amendment takes away from the states their broad and nearly plenary power to determine the manner of selecting their electors in the manner that they see fit. As this court said in Chiafalo, that power is nearly plenary unless something in the Constitution tells states they can't do it. And the structure of the 14th Amendment certainly was intended to expand federal power and certainly to restrict state power in some ways. But states are bound to enforce and apply, for example, Section 1 of the 14th Amendment. And so it's hard to see why states wouldn't be similarly bound or at least authorized.
That's not greater includes the lesser argument. The states have the power, the legislature has the power to choose electors, granted. But just because there's one authorized means in the Constitution to a particular end does not mean that there's any means to that end. And so I think you're taking that electors argument and bringing it into Section 3, where, as the Chief Justice says, there's just no, and Justice Thomas, there's no historical evidence to support the theory of Section 3, nor the overall, to explain the overall structure of the 14th Amendment.
We certainly have a long history in this country of states using their power to determine the manner of selecting presidential electors to enforce other qualifications in the Constitution. I don't take it there's a great debate about whether or not states are allowed to exclude underage or foreign-born candidates, or if President Bush or Obama wanted to run for a third term, that they could be excluded under that broad Article 2 power. I don't see why Section 3 should be treated any differently. Section 3 speaks in the same.
Well, when you look at Section 3, the term insurrection jumps out. And the questions are, what does that mean? How do you define it? Who decides? Who decides whether someone engaged in it? What processes, as Justice Barrett alluded to, what processes are appropriate for figuring out whether someone did engage in that? And that's all of what Chief Justice Chase focused on a year after the 14th Amendment to say, these are difficult questions, and you look right at Section 5 of the 14th Amendment, as the Chief Justice said, and that tells you Congress has the primary role here. I think what's different is the processes, the definition, who decides questions really jump out at you when you look at Section 3. Your response to that?
Well, certainly, Justice Kavanaugh, there has to be some process for determining those questions. And then the question becomes, does anything in the 14th Amendment say that only Congress can create that process? And Section 5 very clearly is not an exclusive provision. It says Congress shall have power.
But maybe put most boldly, I think that the question that you have to confront is why a single state should decide who gets to be president of the United States. In other words, this question of whether a former president is disqualified for insurrection to be president again is, just say it. It sounds awfully national to me. So whatever means there are to enforce it would suggest that they have to be federal, national means. Why does, if you weren't from Colorado and you were from Wisconsin or you were from Michigan, and it really, what the Michigan Secretary of State did is going to make the difference between, whether candidate A is elected or candidate B is elected. I mean, that seems quite extraordinary, doesn't it?
No, Your Honor, because ultimately it's this court that's going to decide that question of federal constitutional eligibility and settle the issue for the nation. And certainly it's not unusual that questions of national importance come up.
Well, I suppose this court would be saying something along the lines of that a state has the power to do it. But I guess I was asking you to go a little bit further and saying, why should that be the right rule? Why should a single state have the ability to make this determination, not only for their own citizens, but for the rest of the nation?
Because Article 2 gives them the power to appoint their own electors as they see fit. But if they're going to use a federal constitutional qualification as a ballot access determinant, then it's creating a federal constitutional question that then this court decides, and other courts, other states, if this court affirms the decision below, determining that President Trump is ineligible to be president, other states would still have to determine what effect that would have on their own state's law and state procedure.
Well, I
in terms
mean,
of ballot
if
access.
we affirmed and we said he was ineligible to be president, yes, maybe some states would say, well, you know, we're going to keep him on the ballot anyway. But I mean, really, it's going to have, as Justice Kagan said, the effect of Colorado deciding, and it's true, I just want to push back a little bit on, well, it's a national thing because this court will decide it. You say that we have to review Colorado's factual record with clear error as the standard of review. So we would be stuck, the first mover state here, Colorado, we're stuck with that record. And, you know, I don't want to get into whether the record, I mean, maybe the record is great, but what if the record wasn't? I mean, what if it wasn't a fulsome record? What if, you know, the hearsay rules are, you know, one-offs? Or what if this is just made by the Secretary of State without much process at all? How do we review those factual findings? Why should clear error review apply? And doesn't that just kind of buckle back into this point that Justice Kagan was making, you know, that we made with Mr. Mitchell, too, that it just doesn't seem like a state call?
3 points, Your Honor. The first is that ordinarily, of course, this court reviews factual findings for clear error, but President Trump made the point in his reply brief that sometimes on constitutional questions that require a uniform resolution, this court can do something more like a Bose Corp-style independent review of the factual record. And we would have no objection to that, given that the record here, really the facts that are disputed here are incredibly narrow. The essence of our case is President Trump's own statements that he made in public view for all to see.
But then that's saying that in this context, which is very high stakes, if we review the facts essentially de novo, you want us all to just watch the video of the ellipse and then make a decision without any deference to or guidance from lower court fact-finding? That's unusual.
Well, ultimately, President Trump himself urges this court to decide the merits of his eligibility on the factual record here at page 2 of his brief. He's never at any point in this proceeding suggested there was something else that needed to be in the factual record, any other witnesses that he wanted to call to present his case. And again, the essence of our case is his own statements, and in particular, his own videotaped statements on the ellipse.
Mr. Murray, just to circle back to, I'm sorry to interrupt, but I wanted to, before we left it, I wanted to circle back to where Justice Kagan was. Do you agree that the state's powers here over its ballot for a federal officer election have to come from some constitutional authority?
Members of this court have disagreed about that.
I'm asking you.
The majority of this court has said that those powers come from Article 2, but we think that the result is the same whether the court locates it in Article 2 or in a reserved power under the 10th Amendment.
But you accept that this court has held. You're not contesting this or asking us to revisit that decision in Thornton or term limits or whatever you want to call it, that it has to come from some federal constitutional authority.
No, we are not, Your Honor.
Okay. And here we're not talking about the qualifications clause, right? Nobody's talking about whether he's 35 years old or natural born, whatever, right? Not an issue, okay? We're talking about something under the 14th Amendment and Section 3. So that's where you have to find your authority, right?
We find our authority in Article 2, in states' plenary power to run their election.
Federal election, but this is for a federal office. It has to come from the Constitution, and you're seeking to enforce Section 3.
We're suggesting that in their broad power to determine them, to select presidential electors in any manner they see fit, they can take account of Section 3 and apply Section 3.
Could they do it without Section 3? Could they disqualify somebody for, on whatever basis they wanted outside of the qualifications clause?
That would run into term limits,
I would think so, right? So it has to come back to Section 3. And if that's true, how does that work, given that Section 3 speaks about holding office, not who may run for office? It was a point Mr. Mitchell was making earlier, and I just wanted to give you a chance to respond to it, because it seems to me that you're asking to enforce in an election context a provision of the Constitution that speaks to holding office. So it's different than the qualifications clause, which is all about who can run and then serve. Yeah.
I don't know that it is different.
Okay.
Other qualifications for office similarly talk about eligibility for the office. There's nothing unconstitutional about a 30-year-old trying to get on the ballot.
Except for this disability can be removed, right, under Section 3. That's what's different about it. So thoughts on that?
Well, the fact that there's an extraordinary provision for removing the disability does not negate the fact that the disability exists today, and it's existed since January 6, 2021, when President Trump engaged in insurrection against the Constitution.
So were his actions after that date, before he left office, ultra vires? Is that where your theory leads?
Well, that would raise the separate question of whether one can collaterally attack the actions of a de facto officer. And that may be the one place in Griffin's case at the very end where we would agree, which is when Justice Chase said, I've talked to my Supreme Court colleagues and we unanimously agree that you can't collaterally attack all official actions of an officer who's in fact holding the position under
but
Section.
just circle back to where we started, right? That this is Section 3, your authority has to come from there, and it's about holding office, and it's a particular kind of disability that can be removed by Congress, and it's the only one like that, right? They can't remove age or citizenship. How should that inform our thoughts about a state's efforts to regulate the ballot for a federal office?
The colloquy that my friend had with Justice Alito earlier, I think, is illustrative here. The fact that Congress has an extraordinary removal power does not negate that the disability exists today and exists indefinitely into the future, much like the fact that that the president can pardon somebody for a criminal conviction doesn't make that conviction somehow contingent. And I would note that if President Trump were appointed to an office today, if he were appointed as a state judge, he could not hold that office, which shows that the disability exists now. And the fact that Congress has a power to remove the disability doesn't negate the present qualification, nor does it implicitly bestow on President Trump a constitutional right to run for offices that he cannot hold in violation of state law and state procedure under Article 2.
In fact, there was a congressional action to permit Confederate officers or people who supported the Confederacy to hold office before the 14th Amendment, correct? So there must have been a thought that there was a pre-existing disqualification.
That's absolutely right. There were a flood of amnesty requests even before Section 3 went into effect, because everybody understood at the time that those people would be disqualified the moment that Section 3 was enacted forever unless they received amnesty.
Counselor, what do you do with what would seem to me to be plain consequences of your position? If Colorado's position is upheld, surely there will be disqualification proceedings on the other side, and some of those will succeed. Some of them will have different standards of proof. Some of them will have different rules about evidence. Maybe the Senate report won't be accepted in others because it's hearsay. Maybe it's beyond a reasonable doubt, whatever. In very quick order, I would expect, although my predictions have never been correct, I would expect that a goodly number of states will say, whoever the Democratic candidate is, you're off the ballot, and others, for the Republican candidate, you're off the ballot, and it'll come down to just a handful of states that are going to decide the presidential election. That's a pretty daunting consequence.
Well, certainly, Your Honor, the fact that there are potential frivolous applications of a constitutional provision isn't a reason.
Well, no, hold on. I mean, you might think they're frivolous, but probably the people who are bringing them may not think they're frivolous. Insurrection is a broad term, and if there's some debate about it, I suppose that will go into the decision, and then eventually what we would be deciding whether there was an insurrection when one president did something as opposed to when somebody else did something else. And what do? Do we wait until near the time of counting the ballots and sort of go through which states are valid and which states aren't?
There's a reason Section 3 has been dormant for 150 years, and it's because we haven't seen anything like January 6th. Since Reconstruction. Insurrection against the Constitution is something extraordinary.
It seems to me you're avoiding the question, which is other states may have different views about what constitutes insurrection. And now you're saying, well, it's all right because somebody, presumably us, are going to decide, well, they said they thought that was an insurrection, but they were wrong. And maybe they thought it was right. And we'd have to develop rules for what constitutes an insurrection.
Yes, Your Honor. Just like this court interprets other constitutional provisions, this court can make clear that an insurrection against the Constitution is something extraordinary. And in particular, it really requires a concerted group effort to resist through violence, not some ordinary application of state or federal law, but the functions mandated by the Constitution.
On your point
itself.
that it's been dormant for 155 years, I think the other side would say the reason for that is Chief Justice Chase's opinion in 1869 in Griffin's case, to start, which says that Congress has the authority here, not the states. That's followed up by the Enforcement Act of 1870, in which Congress acts upon that understanding, which is followed, and there's no history contrary in that period, as Justice Thomas pointed out. There's no history contrary in all the years leading up to this of states exercising such authority. I think the reason it's been dormant is because there's been a settled understanding that Chief Justice Chase, even if not right in every detail, was essentially right, and the branches of the government have acted under that settled understanding for 155 years, and Congress can change that. And Congress does have Section 2383, of course, the Insurrection Act criminal statute, but Congress could change it, but they have not in the 155 years in relevant respects for what you want here today, at least.
No, Justice Kavanaugh. The reason why it's been dormant is because by 1876, essentially all former Confederates had received amnesty, and we haven't seen anything like an insurrection since then. I'd like to address your point.
Well,
Can I go to that point?
After the,
Justice Alito?
I don't know how much we can infer from the fact that we haven't seen anything like this before, and therefore conclude that we're not going to see something in the future. From the time of the impeachment of President Johnson until the impeachment of President Clinton, more than 100 years later, there were no impeachments of presidents. And in fairly short order over the last couple of decades, we've had 3. So I don't know how much you can infer from that.
Certainly, but if this court affirms, this court can write an opinion that emphasizes how extraordinary insurrection against the Constitution is and how rare that is, because it requires an assault not just on the application of law, but on constitutionally mandated functions themselves, like we saw on January 6th, a coordinated attempt to disrupt a function mandated by the 12th Amendment and essential to constitutional transfer.
Well, let me ask you a
presidential
question
power.
about whether the power that you've described as plenary really is plenary. Suppose that the outcome of an election for president comes down to the vote of a single state, how the electors of the vote of a single state are going to vote. And suppose that candidate A gets a majority of the votes in that state, but the legislature really doesn't like candidate A, thinks candidate A is an insurrectionist, so the legislature then passes a law ordering its electors to vote for the other candidate. Do you think the state has that power?
I think there may be principles that come into play in terms of after the people have voted that the state can't change the rules midstream. I'm not sure because I'm not aware of this court addressing it. And certainly,
well, let's change it so that it's not after the election. It's 3 days before the election, based on the fact that the polls in that state look bad. Can they do it?
I think they probably could under this court's decision in Chafalo, where this court emphasized that for much of American history, state legislatures picked their own electors and assigned their own electors themselves. But of course, that would be much more extraordinary than what we have here, which is simple application of normal state ballot access principles to say that we're only going to put on the ballot an individual who is qualified to assume the office.
Could I ask you again the question that Justice Gorsuch asked, and to which you responded by citing the de facto officer doctrine? But suppose we look at that going forward rather than judging the validity of an act committed between the time when a president allegedly engages in an insurrection and the time when the president leaves office. During that interim period, would it be lawful for military commanders and other officers to disobey orders of the president in question?
I'm not sure that anything gives military officers the authority to adjudicate effectively the legality of the presidency.
Why not? Because you say he's disqualified from the moment it happens. Now, I understand the de facto officer doctrine might be used to prohibit people from seeking judicial remedies for decisions that take place after the date he was disqualified. But if he is in fact disqualified from that moment, why would anybody have to obey a direction from him?
Well, ultimately, there still has to be some kind of procedure in place to adjudicate the disqualification. Certainly, Congress could impeach a sitting president, but that's the only remedy I'm aware of that exists for removal or otherwise negating the authority of a sitting president.
Why?
Well,
On what theory? Because the Section 3 speaks about disqualification from holding office. You say he is disqualified from holding office from the moment it happens.
correct, but nevertheless.
So it operates, you say that there's no legislation necessary. I thought that was the whole theory of your case. And no procedure necessary. It happens automatically.
Well, certainly you need a procedure in order to have any remedy to enforce the disqualification, which is different.
That's a whole separate question. That's the de facto doctrine. It doesn't work here. Okay, put that aside. He's disqualified from the moment, self-executing, done. And I would think that a person who would receive a direction from that person, the president, former president, in your view, would be free to act as he or she wishes without regard to that individual.
I don't think so, because I think, again, the de facto officer doctrine would nevertheless come into play to say this is
no de facto. That doesn't work, Mr. Murray, because de facto officer is to ratify the conduct that's done afterwards and insulate it from judicial review. Put that aside. I'm not going to say it again. Put it aside. Okay. I think Justice Alito's asking a very different question, a more pointed one, and more difficult one for you. I understand, but I think it deserves an answer. On your theory, would anything compel a lower official to obey an order from, in your view, the former president?
I'm imagining a situation where, for example, a former president was, a president was elected and they were 25 and they were ineligible to hold office, but nevertheless they were put into that office.
No, we're talking about Section 3. Please don't change the hypothetical, okay? Please don't change the hypothetical. I know I like doing it too, but please don't do it, okay?
Well, the point I'm trying to make is
he's disqualified from the moment he committed an insurrection, whoever it is, whichever party, that happens. Boom. It happened. What would compel, and I'm not going to say it again, so just try and answer the question. If you don't have an answer, fair enough, we'll move on. What would compel a lower official to obey an order from that individual?
because ultimately we have statutes and rules requiring chains of command. The person is in the office, and even if they don't have the authority to hold the office, the only way to get someone out of the office of the presidency is impeachment. And so I think if you interpreted Section 3 in light of other provisions in the Constitution like impeachment, while they hold office, impeachment's the only way to validate that they don't have the ability to hold that office and should be removed.
Mr. Murray, can I just ask you about something Justice Kagan brought up earlier, which is the concern about uniformity and the lack thereof if states are permitted to enforce Section 3 in presidential elections. And I guess I didn't really understand your argument or your response to her about that.
Well, certainly, if Congress is concerned about uniformity, they can provide for legislation and they can preempt state legislation.
Yes, but you say that's not necessary.
But it's not necessary. In the absence of federal enforcement legislation, these questions come up to this court in the same way that other federal questions come up to this court, which is that a state adjudicates them. If the state hasn't provided sufficient process to comport with due process, a notice, and opportunity to be heard, one can make those challenges. But assuming, as here, we have a full evidentiary record, an opportunity to present evidence.
No, I understand that we could resolve it so that we have a uniform ultimate ruling on it. I guess my question is why the framers would have designed a system that could result in interim disuniformity in this way, where we have elections pending and different states suddenly saying you're eligible, you're not, on the basis of this kind of thing.
Well, what they were concerned most about was ensuring that insurrectionists and rebels don't hold office. And so once one understands the sort of imperative that they had to ensure that oathbreakers wouldn't take office, it would be a little bit odd to say that states can't enforce it, that only the federal government can enforce it, and that Congress can essentially rip the heart out of Section 3 by a simple majority just by failing to pass enforcement legislation. Federalism creates redundancy, and here, the fact that states have the ability to enforce it as well, absent federal preemption, provides an additional layer of safeguards around what really Section 3.
Yeah, and I'll ask you about the history when I get a chance again. Thank you.
Thank you, counsel. Justice Thomas? Justice Alito?
Suppose there's a country that proclaims again and again and again that the United States is its biggest enemy, and suppose that the President of the United States, for diplomatic reasons, think that it's in the best interests of the United States to provide funds or release funds so that they can be used by that country. Could a state determine that that person has given aid and comfort to the enemy and therefore keep that person off the ballot?
No, Your Honor. This court has never interpreted the aid and comfort language, which also is present in the treason clause. But commentators have suggested, it's been rarely applied because treason prosecutions are so rare, but commentators have suggested that, first of all, that aid and comfort really only applies in the context of a declared war, or at least an adversarial relationship where there is, in fact, a war between two countries. And second, the intent standard would do a lot of work there, because under Section 3, whatever the underlying conduct is, engaging in insurrection or aid and comfort has to be done with the intent to further the unlawful purpose of the insurrection or to aid the enemies in their pursuit of war against the United States.
Now, let me come back to the question of what we would do if different states had adjudicated the question of whether former President Trump is an insurrectionist using a different record, different rulings on the admissibility of evidence, perhaps different standards of proof. Then what would we do?
Ultimately, this court would, first of all, if there were deficiencies in the record, the court could either refuse to hear the case or it could decide on the basis of deficiencies of the record.
Well, would we have to decide what is the appropriate rule of evidence that should be applied in this case? Would we have to decide what is the appropriate standard of proof? Would we give any deference to these findings by state court judges, some of whom may be elected? Would we have to have our own trial?
No, Your Honor. This court takes the evidentiary record as it's given, and here we have an evidentiary record that all the parties agree is sufficient for a decision in this case. And then, as I discussed earlier, there's a possibility of a Bose Corp independent review of the facts. But ultimately, what we have here is an insurrection that was incited in plain sight.
But you're really not answering my question. It's not helpful if you don't do that. Suppose we have two different records, two different bodies of evidence, two different rulings on questions of admissibility, two different standards of proof, two different sets of fact findings by two different judges, or maybe multiple judges in multiple states. Then what do we do?
Well, first, this court would set the legal standard, and then it would decide which view of the record was correct, I think, under that. If this court had two cases,
which view of what record?
Which record? If this court had two cases before it, and both of the records were sufficient insofar as both sides had the opportunity to present their case and the essential facts in the record that everyone agreed was sufficient for decision, then this court would have to look at the evidence presented and decide which holding was correct, and then decide that issue for the country. And certainly here, when there is a complete record, lower courts then will be applying that decision, and I think it's unlikely that any court would say, we're going to reach a different decision than the U.S. Supreme Court did, particularly